Good afternoon, everyone. So now we finished the session on brainstorming session based on experience from various countries and our current experience in Thailand on digitalization. What was the challenge that we are facing nowadays in court, and as well as what is digital technology that we are using at the moment, and also opportunity for the future in apply digital technology in court in Thailand. And now it's our honor to have a speaker, distinguished speaker who have experience on that. And everyone knows that UK is ranked very high in terms of digital transformation and has become a good practice for many countries. And digital technology has also used in various sectors, including in court of justice as well. So today we have an honor to have our distinguished speaker, the Honorable Justice Philip St. John Stephen, acting judge of the Grand Court, Cayman Island, UK. May I invite Honorable Justice Philip St. John Stephen to speak.
Now, can I confirm this is being simultaneously translated? Is that correct?
Yes, sir. Yes.
All right. So I'm going to go perhaps a lot slower than I normally would, but if anyone, I'm sure very good and professional translators, or I'm going too quickly, perhaps somebody could indicate. And I anticipate that perhaps what I have to say will last perhaps 40 minutes and then open to questions. I hope that is the appropriate length of time. That was what I was told. If it's too long or whatever, perhaps you would be kind enough again to indicate. Thank you.
We confirm, sir. Yeah.
Thank you. All right. I don't know how many participants are watching, but may I say straight away, good afternoon to all of you. And firstly, and most importantly, may I express my humble gratitude to be of being invited to speak to you all, to speak to such a respected audience. May I extend a warm welcome to you all from England. It's 9 a.m. I'm in the middle of an attempted murder trial at the moment in a court in Kent, which is southeast England. But to all of you, and particularly all my sister and brother judges, a warm welcome. We have a unique bond, a bond being from the fact as judges, we on a daily basis ensure everyone is treated equally and fair. And we do that treating people fairly and equally, whoever they are, whatever their background is. And as judges, we, on a daily basis, question ourselves as to our integrity and if we are being fair. It is a burden that we all have. May I take a moment before I embark on the body of my speech to you, is just to explain who I am. You may have been told, but may I take a moment perhaps to lay the foundation as to how and why I'm lucky enough to speak to you all. I am what is described in England and Wales, a circuit judge. I'm one of about 600 or so judges, but one of a smaller number described as a class 1 judge. That means the level I am at, I deal with the most serious of crime, murders and terrorist cases. And I've been doing that for, in total, almost 20 years. I also sit as a Grand Court judge in the Cayman Islands in the Caribbean. That is the highest level of court at first instance. And I do all types of work at that court. Without descending into all the detail of my background, I was a lawyer, previously Attorney General on a Caribbean island called Montserrat. I am a member of the International Training College in England and Wales, lecturing in cybercrime, blockchain, artificial intelligence, and the rules of law. And my experience in terms of technology perhaps started 10 or 15 years ago. I was one of a number on a committee who identified a paperless court system to be used in England and Wales in the criminal courts. We looked at a court system that helped judges do their work as judges. And so I've had an experience over a decade looking at how that works. In terms of COVID, I was the lead judge dealing with the training and implementation of video hearings to allow the courts to run. And that's a role I continue to do in terms of reflecting on how video hearings have worked and how they will work in the future, and looking at all areas of technology in the courts in this country. Also in the Cayman Islands, I'm assisting them in identifying a digital case system. And I've lectured to a number of jurisdictions through the United Nations Development Programme to 9 Caribbean countries by way of introduction. I've attended lectures and spoke in a number of countries as far apart as Jamaica in the Caribbean, in Italy. Sadly, I've never been to the part of the world where each of you are from, and I have a great honor to speak to you all. I last had the good fortune to travel to Thailand some 32 years ago. Perhaps in many ways it's changed, but what I'm sure has not changed is my recollection of the warmth and generosity of its people. Much, I'm sure, has changed in 32 years, but even more so in the last 2 years. Certainly the terrible impact of the COVID pandemic that it's had on all of us, both personally and professionally. Legal systems around the world have responded to COVID. They've had to act quickly, in some cases, radically changing the way their courts worked, and needs must reaction. Changes that may have been a wish or desire to change in the future became an immediate and necessary change that allow our court systems to continue to function. I'm absolutely confident that within each of your legal systems, you've shown remarkable strength and industry to use technology to keep your courts and the legal systems running. I'm sure of that from everything I've read and the research I've done before today. We've all found our ways around the problems, but perhaps now it's time for us all to pause and draw a breath and reflect about what we have done. Perhaps to applaud us all, but also to reflect on the systems we have created, allowing us time to consider as to which systems or processes have worked, which haven't, which can be improved. Any new systems requires a critical evaluation. which wasn't perhaps possible when we were all running as fast as we could in order to keep our courts running during COVID. As I've set out, I come from the perspective of a judge sitting in England, a judge sitting in the Cayman Islands, but I'm sure that we can all learn from each other. I know that each one of you will have processes and solutions that I can learn from, better ways. This is a collaborative approach. In a way, what a wonderful opportunity that worldwide we can use our collective wisdom and knowledge to see if we can do things in a better way. Perhaps as judges, we all know that sometimes there's not necessarily a wrong or a right way of doing something, but often a better way. We must all be our harshest critics. We must all strive to be better. In my jurisdiction, we continue, and even more so, to critically examine the use of technology that we have now, and the use of technology that we may use in the future and the process around it. Part of that critical analysis revolves around whether the court integrity is in any way eroded or reduced. Of course, technology cannot and must never erode the integrity of the court system or the integrity of judges. Perhaps many of you will agree with this, that the integrity of the court system and the integrity of the judges working in that system go hand in hand. We in England and Wales and in the Cayman Islands have begun the evaluation and assessment of technology. And if I may, it may assist to set out really the two different areas that we are looking at. What I intend to do in my address to you is to look at some of the ways that we have used technology. Look at some of the ways that we have concerns about how technology is and may be used, and reflect upon how we as judges and the use of technology must never compromise or call into question our integrity. In terms of evaluating the use of technology, there can be perhaps two main heads or positions to reflect upon. Firstly, a quantitative assessment. What I mean by a quantitative assessment is, what is the quantity of work? Is it more efficient in the sense of how many cases can be heard and processed? I'm sure we'll all agree that technology in terms of filing documents and having cases without paper speeds up those processes, as do in many jurisdictions the use of artificial intelligence and machine learning to at least filter a mass of documents. So that's the quantitative assessment. Perhaps more importantly, if I may express a personal view, is the qualitative assessment. What is the quality of the product in terms of how it impacts the quality of the court process and the legal process? Of course, we have the quality of the technology, which is in every day getting better. But what about the quality of witnesses giving evidence? The quality of access to the court system for those less fortunate in economic minorities that perhaps don't have access to an internet, to computers? What is the human level of the quality of the court system that technology may provide. And of course, there is also within the quality of the court system, the quality of judges. The quality of judges, and may I speak on a personal level, and many of you may agree or disagree, but I find dealing in cases remotely, that is with all participants on a screen, tiring. To marshal and to control a court remotely, it is tiring, and there's that burnout and welfare on judges, which can impact upon their work. And there's a great deal of work looking at, as it were, screen time and the ability of judges to work as efficiently as perhaps they would do in a courtroom. So that's the foundation, if I may, and I'm sorry I've taken a little more of your time than I'd hoped setting that out. But turning to the topic of your course about promoting judicial integrity through digital transformation. What is judicial integrity? Well, we all know as judges that it's not just what we do as judges, but it's how it is perceived from the outside. To be acting with integrity is fundamental, as is to be seen to be acting with integrity from an independent and impartial observer watching or being engaged in the court process. What I would like to focus on with technology, I make no apology to return to this theme a number of times, is to look at safeguards of human rights, the safeguard of the court system, enshrined what perhaps universally as a philosophical position, the rule of law, the concept that no one is above the law, that any forum should be an open and transparent forum. In many different jurisdictions, countries have constitutions, bills of right, legislation which enshrine and embody human rights. But ultimately, it is, as you and I, judges, hold that fairness and ability to safeguard others in our hands on a day-to-day basis. A pillar of every legal system is open justice. That is a system that is open to all and open to scrutiny by all. And the integration of technology and technological process must always serve and be compliant with fundamental rights. It must facilitate, and there must be no erosion of those rights. To allow those rights to be eroded in any way must inevitably, you may think, undermine the integrity of the judiciary as well as the court process. Technology must serve and not be the master of any processes within a legal system. It must facilitate the court process, and the court process must not in any way bend to facilitate the use of technology. The two-day forum that I have the pleasure of speaking to now, its title is Promoting Judicial Integrity Through Digital Transformation. If I may, and I hope you don't think this presumptive or rude of me, perhaps would like to put it in this way and recast that title as to, rather than promoting integrity, should perhaps be described as maintaining integrity. and not digital transformation, but digital facilitation. So perhaps another way we can consider everything that we're learning is to ask ourselves and describe it in this way. Is it perhaps maintaining judicial integrity through digital facilitation? What of open justice? At the core of every legal system, a process and a court system open to all. Open to all, mindful that the further we descend and use technology may mean that other disadvantaged or discriminated sections of our community feel further away from a court system if they simply do not have the technology, the confidence to engage in a court system using more and more technology. So open justice is open to all and effectively open to all. And perhaps we must always, when looking at the use of technology, ask ourselves, is the most disadvantaged part of our society really able to engage in the court system? In England, we've looked carefully at that in terms of video-linked hearings, having the facility to dial in on a simple phone or to go to another court centre where there is the equipment to ensure that although we bombard people daily with emails, some people haven't been fortunate enough to have the education to be able to read or perhaps understand those emails. We must always ask ourselves whether the system we are generating is really open to all. The other element of open justice is that it's open for people to spectate, to watch, to monitor by people that are interested in the case. In a criminal case, the victims of crime, the families of the victims, but also for academics and lawyers to scrutinize and ensure that the court process, as well as the court's decision, is open and transparent and is open to critical evaluation. Because what we all want as judges is a fair court system, a system that's fair to all and that imposes minimum standards, both in terms of procedure and the substantive result of any hearing. And as judges, and I've said before, and I apologize for repeating it, ultimately, we are the custodians of fairness. We hold that precious bird in our hands to nurture and ensure that it runs through all of the court processes that we preside over. Perhaps we must constantly reflect and pose questions as to whether procedural fairness can be eroded by the use of technology. Asking ourselves, does any use of technology undermine our ability as judges to protect fairness, or indeed the appearance of fairness? Could the use of technology have the possibility of compromising our integrity? These are all questions that you may think, should be constantly alive to. What about the areas of digitalization, certainly that we use in England and Wales and Cayman? May I reflect in relation to those? There are perhaps three main heads and areas of digital transformation. There is what I described as the pre-hearing, the case filing. The parties filing documents to the court, sometimes in the world we live in, a vast quantity of documents, lodging those formal papers, having a repository or storage of those papers, it is the first part of digitalization. Of course, bolted onto that in some jurisdictions, they use artificial intelligence, machine learned sifting to identify issues within that case file. Artificial intelligence and open justice is a topic I will return to. So the first heading is what I call the case filing, the management of a case. The second heading is in relation to the court hearings, having hearings without paper, having hearings where people can take part remotely via Zoom or other video platform. A process where multimedia video footage can be shown to the tribunals of fact, whether they be jurors or judges. The next head is decision-making, perhaps a more contentious area in terms of the use of technology. What I mean by decision-making is the use of artificial intelligence to make decisions in terms of the outcome of a case. Some jurisdictions, such as Brazil and others around the world, India to an extent, use artificial intelligence, a computer program effectively, to identify the main issues and perhaps look at what would be the most likely result. That's decision-making in the first instance. Perhaps often judges, without perhaps reflecting upon it, use artificial intelligence or the product, not to make and decide the initial decision. Perhaps in a criminal case, that would be a matter for a jury or a judge. But in terms of, for example, reports identifying future risks of criminals, where data and the personal attributes of a criminal is fed into a system, and it makes a decision as to whether somebody is and presents a danger or not. These are all the use of artificial intelligence. Focusing on that for a minute, what would, in my judgment, undermine any judicial integrity of the court as well, it is in using machine learning and artificial intelligence, the opacity of the decisions. What I mean is whether, when one uses a computer program, whether there's transparency into how that particular computer algorithm has produced the result it has. What are the parameters within the algorithm that's built? What is the response data used to construct and respond? An algorithm such as that, of course, the computer learns to use historical data to predict future positions. But one cannot ignore the possibility of algorithmic or machine bias when one reflects upon whether any digital and artificial intelligence really facilitates and perhaps exacerbates or makes worse a digital divide in terms of gender diversity, pluralism, equality, and the concerns that many jurisdictions have is that that simply can't be properly analyzed by anyone. Is there open justice in terms of that element of the decision making? bias could be present in the data set, unknown to a judge that uses the product of that artificial intelligence. I will return to that subject, if I may, later with some examples. But with that background, in the sense of being alive to the dangers of digital transformation, and may I say straight away, I'm the greatest champion, the greatest supporter of use of digital technology in courts. Well, that is the hat that I wear. But the more I've become, if I may say, an expert or have greater knowledge, the more I've realized that we must use that tool with care. So what was the immediate response in England and Wales to COVID? We should perhaps all pause to reflect on the terrible human cost of COVID, that many of us have been touched very personally. And I extend those thoughts to all of you. But what about the effect on our courts and trying to maintain that? In England, we had the benefit of a wholly paperless court system, which I'm sure many of you had. That court system is cloud-based. It ensures the integrity of the system and the judges, in the sense that there is within that court system an audit trail. One can see when and who uploaded documents. One can see who and when looked at the case and the exact date, day and time they did. Of course, there's the ability, without descending into too many technical aspects, we all know in any document to look at the hexadecimal value to see if it's at all been tampered with. It also has the benefit, the digital system in my jurisdiction, that all the documents, once they're uploaded, have been firstly filtered and ensure that there are no viruses, but they're also optical character recognition software of the highest level applied. So any document, one can search and extract words and material, whether that be in writing, manuscript or typed, which allows a judge his jobs much easier. So we had that in place, but our court systems were closed. People weren't allowed to visit the courts. We had no law that provided or allowed for people, the lawyers, to attend remotely. The government had to implement laws to facilitate that. We had to quickly get up and running a video system. It's really analogous to Zoom. It is a different name, but in all intents and purposes, a video platform. I, within 3 months of COVID, had visited remotely and trained over 600 judges to use technology, both in terms of which button to push at which time, but also to ensure that the integrity of the court system was preserved, making sure that those joining a hearing remotely understood it was a court hearing, that they had to approach it with the appropriate solemnity and dignity, in effect taking it serious. At first, we had completely video hearings. People were joining on iPhones, other smartphones, tablets, computers. It was always a concern at that stage about open justice and other people. How do they watch? At the first instance, those that were joining into the court system were only participants in the terms of lawyers, judges, and witnesses. What we did do is quickly set up another room that could be visited, where it was sent to so others could watch it, and particular individuals could apply to join that video hearing. It remained the position that many individuals simply didn't have the ability to join those hearings, defendants in criminal cases. And that caused a delay in the processes. But very quickly, the court was up and running, dealing with cases. We never deal with cases with jurors, never did remotely, but other cases we did. What we ensured was that there was always a recording of every hearing. So if anyone afterwards, press or any academics, they could watch and or listen to the hearing. That, through necessity, was the position which, in all the circumstances, safeguarded open justice, that any hearing was recorded and was open to scrutiny by anyone if they applied to watch it. Perhaps not as good as the ability somebody simply to walk into a court and watch, but it meant that no hearing was done without there being a record that could be scrutinized to ensure that there was the integrity of the court system was adhered to. During COVID times, we engaged in that process, asking ourselves the questions that I've posed perhaps before, as to whether it was a fair system, whether it was an open system, whether people had effective access to it. And asking ourselves, did at any time the use of technology increase the divide between the legal systems and those disadvantaged people in our society and their ability to access it, or their belief that they had an inability to access it? We've moved on from that position. We now are back in courts. COVID, a memory, if not a distant memory. We move on. We've all lived, learned to live, and function perhaps in a very different way. We have now still the remnants of the digital video platform that we used. I'm now looking at the next generation to be used in our courts. And I'm looking critically as member of a larger committee as to the quality of a court hearing. I don't descend into all the details. Perhaps they're familiar to you all. But research is being done that I'm part of in terms of the use of videos for the receiving of evidence from people remotely for tribunals of fact, such as judges and juries. There's been a proven impact in terms of the size of the image of the witness giving evidence. It may sound obvious to all of you, intelligent and understanding judges you are, but perhaps worth noting that there was an impact, that every witness should be on a screen, and it should be the same head and shoulders view of that witness for each of them. So there's equality in terms of assessing if there's competing evidence given by different witnesses. And it does impact if one witness is a tiny dot in the corner of a screen and the next witness is a head and shoulders, where some tribunal of fact has the opportunity to see and perhaps reflect upon the body language of the person giving evidence. So we are always concerned and looking forward to making sure that technology is serving the court system in the best way it can. May I give you an example of the latest response to the question of open justice and remote observation of hearings in England and Wales? Perhaps it's of two use. One, simply as itself, as an example of how and what we are doing, but it does again underpin and emphasize some of the considerations that us as judges perhaps should have. From the end of June in England and Wales, courts will have powers to allow reporters and members of the public to observe hearings remotely. Previously, there's been an embargo upon anything being broadcast or filmed in court. But obviously, open justice has been a fundamental principle for centuries. It's a broad principle, but at its core has always been a right of access to a public hearing. Remote observation of hearings was allowed in the beginning of the COVID period, but we now have new legislation which provides the court the power to direct that images or sounds of proceedings can be transmitted electronically to enable persons not taking part to watch or listen. There are two kinds of directions that the court can make in this jurisdiction. It's not simply an open streaming of a court. The two directions or positions are, firstly, there is transmission to designated premises for live streaming. Example, another court centre or a public building where there can be some monitoring of those viewing the transmission of proceedings. The second option is where particular individuals who apply to the court are given access. In making the decision as to whether hearings should be transmitted electronically, there are two threshold criteria that the court must consider. First and foremost, and perhaps to all of us reassuringly, is that it must be in the interests of justice to make the order. And secondly, the court must look at the capacity and technological ability to enable any transmission and be sure that any direction that hearing is transmitted would not cause an unreasonable administrative burden. Perhaps included in that is undue delay. That's my own example of that. But perhaps what is interesting is within the legislation, there's considerations that a judge must consider, considerations that she or he must look at that are triggers upon whether technology would be used to transmit a public hearing to others. Firstly, the court must take into account the need for open justice and the impact of that. They must consider the resources available. They must consider whether there's any other limitation on those observing or watching. They must consider whether any observation is by people outside the United Kingdom. The reason being not that the United Kingdom is trying to prevent anyone watching our courts, but of course, if somebody, for example, recorded a transmission to intimidate a witness or a judge, any rules, any prohibitions that were set in this jurisdiction, meaning England and Wales, could not be invoked, would have no teeth for others outside. And so there may be different consideration when reflecting upon the transmission of a court hearing to jurisdictions outside England and Wales. The courts also must consider, when deciding whether to make or not such a direction that a hearing can be transmitted, the content and quality of the evidence. Secondly, the public understanding whether a portion or all can be misunderstood. Thirdly, mindful of the ability of media and public to observe and scrutinize the proceedings. And within the impact is the safety and the right of privacy of any person involved in the proceedings. May I give an example? A vulnerable victim of rape, a female whose anonymity needs to be protected, a vulnerable witness who may feel in giving evidence, understanding that her evidence is being transmitted, may not give the best evidence. Perhaps these to you are all obvious matters to consider, but perhaps reassuring that in legislation in this country they are being acknowledged. But perhaps more reassuringly is that the decision whether to permit remote observation of a case is and will always remain a judicial decision, a decision of the judge looking at the factors of the particular case, weighing up those criteria I've considered, and indeed any other. That's not a closed list. It is not an administrative decision. It's not one where the court service, for want of a better description, says this case will be transmitted to others. It is and must remain a judicial decision. The judge, she or he, must decide whether, looking at one of the gateways or threshold criteria, ultimately, whether it's in the interest of justice, in this case and more widely, that technology is used, asking themselves, does it at all erode the integrity of the court process? Does it in any way reduce the quality of the evidence, the quality of the legal system and the hearing? Decision makers must consider and balance that open justice serves the key function of exposing the judicial process to the public scrutiny. Of course, that is essential. It allows the public to better understand the process of the court, to have more confidence in the court process, enhancing public confidence in the integrity of the court as a whole. Remote observation of hearings can promote all of those, whether it's access to reporters, legal commentators, or academics. It should be allowed if it is in the interest of justice. It shouldn't be allowed if the circumstances may undermine that, as I've said. For example, a witness being more concerned about being watched than having an open mind to give evidence that is compelling and truthful. May I turn from that example to the Cayman Islands, a small jurisdiction, I'm sure all of you know, in the Caribbean, 500 miles or so south of the United States of America. A small island, but an important island in the sense of its legal system with a great heritage, both in financial services and more widely. It was at the forefront of reacting to COVID. I think I'm right in saying it really didn't lose any time sitting. It used Zoom in a speedy and efficient way, promulgating a system where people could attend remotely. They quickly used Zoom to make sure all parties were present, or that people could dial in if they didn't have the ability to use a computer. They took very little time to grapple with the question of open justice and dealt with it in this way, that from the judicial portal or the court portal of the Cayman Islands, they streamed court hearings live in relation to all of the courts, and if there a particular reason not to. So open justice was met head on, allowing anyone to watch and observe those court processes. They saw no impediment to broadcast the hearings in their jurisdiction. Perhaps it's the great foresight and energy of the Honourable Chief Justice and the support of the admin staff on that island that they simply made it work. They're now moving forward, and I have a small part to assist them in. They now have a digital filing system, e-bundles in their financial services division and all divisions, and they're moving rapidly to identify a paperless court system to be used. That was the Cayman Islands response. I note the time, but I would like, if I may, just to take a moment of your time to reflect on artificial intelligence, perhaps in the rule of law and how it may impinge upon the integrity of judges. Judicial integrity is maintained and fostered by people understanding judicial decisions, good decisions, and transparency of that decision-making process is fundamental. Often a case ultimately reaches the point that it is a binary decision, in sense of a binary decision, whether the answer to the position between a plaintiff and defendant is yes or no, win or lose, guilty or not guilty. But a court, of course, would never simply announce its decision without explaining its reasons so that they can be scrutinized and understood. The understanding, the foundation of confidence for everyone in society, that the law is being applied in a fair and measured way. It wouldn't simply, as I say, announce a decision without reasons. What are reasons? Well, they're given in judgments that we all give on a daily basis. In England and Wales, a case put it this way. Another decision of the court described the purpose of a judgment is this: the reasons for a decision must be intelligible, they must be adequate, they must enable the reader to understand why the matter was decided as it was, and what conclusions were reached on the principal important controversial issues. The integrity of the decision-making process, the clarity of the reasons behind a decision are of paramount importance. A badly explained decision may lead to argument or concern as to whether the ultimate result was correct or incorrect. In every case, somebody is going to be disappointed. But that disappointment should be a position where they can understand why they are disappointed. They can understand why they have lost the case, and to understand that. If they can't, it leaves the possibility that a person who is concerned or upset with a decision because they can't understand how it was made would call into question, and rightly so, the integrity of the decision-making process, the court, and ultimately us judges. Of course, the use of AI, artificial intelligence, and such computer systems predict outcomes. They are used in some jurisdictions to assist judges as to what is the most likely outcome of a decision. But of course, the outcome of the computer program that produces a result is not open to scrutiny. the computer doesn't explain the processes it's gone through. It doesn't explain the nuances of a judge in terms of balancing competing elements and evidence to come to a decision. There's no transparency in the factors, the architecture of the algorithm used, or indeed the primary data used to build the model. There's no transparency in terms of the decision flowing from it. In the United States of America, there was a case where this was tested in a court, where the court was confronted by an argument that the human rights of an individual was simply not adhered to or eroded because there was no ability to know what factors were used to arrive at the answer that the computer did in terms of how that individual was to be incarcerated. In England, we don't use it to make primary decisions, but there are computer programs to look at whether a criminal presents a risk in the future. The concerns that I have, and many, is that a judge can unwittingly adopt a response from an AI-generated decision, which is inherently biased, or maybe because there is bias in terms of algorithmic bias. Of course, a machine learns to replicate and may magnify stereotypical systematic biases in terms of the information that's put in and the data. We have, as judges, are not party to the architecture of the algorithm. We don't know the question the computer is asking itself. What we do know that many computer systems used are based on data from United States and Western Europe. That data may not properly reflect cultural variances or other regional variances. A cultural, religious, or economic minority in a regional country may be different to another, may have a different impact. And so unwittingly, we could be party to using data which is biased, to be using and adopting processes that are not open to scrutiny. I'm not for 1 minute suggesting that AI doesn't have a part to play, but as judges, we must be sure that it's reflect and is useful in our jurisdiction. Human rights, we know, are paramount in all our minds. Can I perhaps leave you this, that human rights evolve on a daily basis. The appreciation and impact of our rights in the modern world we live is ever changing. We as judges adapt and adopt such changes in construing and applying the laws. But any technology must also be updated to reflect that equally so. There is a danger of using machine learning. For example, in England and Wales, we use a program to consider criminals, whether they pose a risk in the future when they have committed serious violent or sexual crimes. That model draws no distinction between male and female in terms of its data, as I understand. And one can understand the concerns a court may have. Ultimately, may I leave you with these thoughts, and thank you for your time and patience. Ultimately, we all sit as judges, as the custodians of fairness in terms of access and treatment and outcome of our respective legal systems. Our individual integrity as judges may be reflected in the integrity of the legal system that we preside over. Whilst use of technology is an exciting tool, which no doubt will assist everyone, we cannot and must not let technology in any way erode the foundation of a fair and open and transparent legal system. we cannot and must not let economic expedience erode such fundamental human rights and freedoms. If we do, that of itself, through no individual judge's fault, may call into question the integrity of the system, and thereafter the integrity of the judges who sit within that system. We must also always ask searching questions as to whether our respective legal systems are in a better place, to ask whether we can use technology in a better way, to look to the future, ensuring that history and the values of our court, our independence and integrity and standing, is in no way being eroded or compromised by the use of technology. Asking ourselves, is the technology allow us to do what we have skill and ability to do, that is, to be fair and impartial judges? As we all strive to embrace technology to enhance judicial integrity, our developing and ever-changing use of technology, we must leave no one behind. Thank you. I'm sorry I've gone on longer than I anticipated, but I hope
No problem.
what I've said was of interest.
Thank you, His Honor. Just a sensitive and mindful of time, but we still have a few minutes for questions. If participants have questions, please feel free to ask. Maybe you speak or you can put in the chat box as well for this few minutes. After that, we'll be wrap up for a few minutes before we finish this seminar. So if anyone have a question, please feel free to ask.
I've stunned the audience, have I?
Yeah, there are many good practical example, but what impressed me, and I think maybe participant too, is about how you think about to safeguard principle when using digital technology. It's not about technology, but make sure that we safeguard principle, right? About the open justice that you mentioned, that have to consider along the way when applying digital technology. So that's a very impressive, and how to think about that principle and when we use technology.
Thank you. We're all about humans, aren't we? Human-centric is the way.
I got a question in the chat box directly to me. Do you, since you mentioned many good practice, do you have any publication or any place that we can go to research for what UK adopt new technology in COVID or even before?
Yes, I will. There are certain places I can send some links through at the government websites. There are certainly.
Yes. Yes.
Say this also, that I know the organizer has my details. If any judge ever wants to contact me, I'll be more than happy to engage in any dialogue via email. I was going to say I'd be very happy to get on a plane to your wonderful part of the world, but of course I'm always here. We are a community of judges worldwide, and we need to support each other intellectually and emotionally.
Thank you, Chas. And actually, I really to say thank you to UK Embassy in Thailand as well to connecting us with you. So maybe in the future we can meet in person in Thailand in the future. So the question, what is the open chance for just to do in online process? Can you explain a little bit on this?
Sorry, explain. I just missed the beginning. Explain.
Maybe participant will ask this question: what is the open chance for just to do in online process? Maybe open, the principle of open justice, right? That you apply when you do the online process. How you safeguard that?
how do we ensure that
May I could ask you about the open chance for judge to have discretion, which kind of case to judge to have decision and or to be the choice of the judge, choice of judge to select the method to use in online process, that such as I want to listen or not listen the evidence, or
yes
use the conference or not use the conference by case. Can you give example of the case that the judge have the chance to select by themselves? Yes.
yes forgive me, I hope I understood. It's my fault if I didn't the question. In terms of open justice in the court, there are examples when I would use technology in a very perhaps imaginative way to protect competing rights. For example, I did a case involving a rape with a vulnerable victim, and she gave evidence over a link, but I ensured that in court, although people could hear what she said, no one could see her except me and the jury. So she was comfortable that the defendant or other people couldn't see her. And so there are situations where, well, in every case, I have the ability as a judge, when I might have the feed of 6 or 7 participants, to mute, to close cameras down, etc., to ultimately have control to ensure there's open justice, but that's balanced with preserving people's rights and ensuring any evidence and or the court process is not eroded. So it's an ongoing and dynamic situation that a judge is in control of. And perhaps what I would say is that, as far as England Wales, and some of you may agree, that it's important that it's a decision of the judge how and when technology is used in her or his court, rather than, as it were, I was going to say government, you understand what I mean, the court service imposing it and saying it must be used, because we all know that one case or 2 cases on paper may look identical, but there are nuances of vulnerability of witnesses and differences that make it important that it must be, in my humble view, a decision for the judge on each case basis, and not generally somebody saying, well, every case of this type is going to be dealt with in this way. Thank you.
Okay, so it's a decision of judge to make judgment whether or not it use online process or not. Then.
Yes, it is, absolutely. And it always must be the decision of the judge who makes a formal direction, having decided whether it's in the interest of justice in that particular case, or in relation to a particular witness or participant in a case. So it means that the judge at every step is saying, is technology the best way to deal with this case before me in this particular situation?
Okay, thank you. I think we don't have anyone who would like to ask now, but if anyone would like to ask a question, you can ask me, and we can collect and ask you through email and address, because we already have, so we can facilitate that questions. And as well, since we receive thank you UK Embassy for connecting us, and as I said that perhaps in the future we may invite you to come to Thailand and give presentation all of these things, because Thailand is a doing a fast on this digital transformation and would like to exchange experience with other countries as well. Thank you so much, this Honorable Justice John Stephen. Thank you.
But thank you, and I hope, and I extend my warm greetings to you all, and I hope at least in small part what I've said has been useful or interesting.
Very useful. Thank you. Thank you so much, Just.
Thank you. Goodbye.
Goodbye. Bye-bye.